We'll hear from the appellant.
Good morning. May I reserve 2 minutes of my time for rebuttal argument, please?
Yes, 2 minutes will be fine.
Thank you, Your Honor. May it please the Court, my name is Joshua Hedrick here on behalf of the appellant, Lance Baker. We urge the Court to reverse the judgment of the lower court on the basis, for 3 reasons, essentially. First, that the parties agree there is no valid retainer contract between Ms. Troy Jones and Trinity Clark. Second, that the retainer contract between Trinity Clark and Lance Baker complies with Rule of Professional Conduct 1.5e. And third, in the alternative, if there is a technical failure in the Clark-Baker contract, that failure does not operate to invalidate the contract. We can dispense with the question of whether there is a contract between Troy Jones and Trinity Clark because neither party, in our brief as well as in the appellee's brief at page 3, neither party raises that as an issue in error. So that leaves us with the next issue, which is, does the Lance Baker Trinity Clark agreement survive review under Rule of Professional Conduct 1.5e? Your Honors, Rule 1.5e does not require the names of the attorneys to be associated and does not require that the agreement's writing reflect the actual share that each lawyer is to receive. We know that from, bless you, we know that from comment 7 to Rule of Professional Conduct 1.5, which specifically says, it, being the written undertaking, it does not require disclosure to the client of the share each lawyer is to receive. So,
but does it require, Mr. Hedrick, some sort of statement that there will be fee sharing?
I believe it does. It does require, the intent is that the client be informed that there will be a sharing, that there will be other, I am not the only lawyer. There's a possibility that there will be another lawyer and that the other lawyer will share in my fee, or alternatively, I'm sorry, I don't want to.
No, you
look like you're very close to a question.
You're right, I am perceptive. Does the Baker contract, it talks about associating attorneys, but does it specifically talk about sharing a fee with them?
So the Baker contract does in a way that it does. Our position is it does in a way that complies with the floor of 1.5. The Baker contract says that the attorney has the right to associate other lawyers. The association of other lawyers will not increase the amount of the client's attorney fee obligation. So that, although we can quibble about the artistry of the drafting, it tells the client, you will owe no more money. And so, at the risk of jumping too far ahead, when we compare that to what the court's dealing with in Cordova and in Coleman, Cordova actually cites Coleman, but Cordova and Coleman, which the parties have relied on extensively, Cordova and Coleman essentially approve, I think approve may be too strong, but Cordova and Coleman are both cases where they have not invalidated the agreement, where the client is aware of an arrangement and does not pay more. And specifically addresses, the courts have said in both of those cases, we're finding this is not a fatal error because the client was aware that there was an arrangement.
So even though, so that kind of gets to the third point. I mean, technically the language of the Baker contract maybe does not talk about fee sharing, but your point to that is, under the case law, it's not a fatal error because she knew, period, it was 45%, and regardless of how any splitting that occurred amongst the attorneys.
And knew that it was 45%. The record indicates that knew that she had signed a written undertaking that says there may be other lawyers, and had actual knowledge of the existence of the other lawyer, and had dealings with the other lawyer. This is a little different. So if we think about Cordova, for example, where you have an attorney who then brings in another attorney sort of in the background, for lack of a better term, right? In Cordova, you have the hired attorney who then associates someone else to assist. In this case, Mr. Jones is in the foreground. He's dealing with the client. He's talking to the client. He is present at mediation. So we have a case where the court is constrained by the record to say that she's aware there is an intent to associate another attorney, and that she's aware that the other attorney will not change her fee. And we can see in the record when the fee settlement is dispersed, it doesn't change her fee. She receives, they are divided just as promised, right? The lawyer receives his share, the client receives her share, and so the agreement that she has is complied with. The client has suffered, as in Cordova and Coleman, suffered no harm. So the problem that we have is that Rule 1.5 sets a floor. And I think, Judge Davis, you're thinking of it in the way that I was thinking of it when I first began to sort of put this together as what should be happening and what's required. And perhaps it would be better if the rule required more, but it doesn't, respectfully. And that must be intentional, because the comment says, we are not requiring you tell the client what the share is. We are specifically not doing that. And the comment says we're specifically not doing that. And if you
I'm sorry to keep interrupting you.
No, that's why I came here.
Did the trial court address the issue of, even if the language of the Baker contract wasn't technically correct, did she address that issue of no harm, no foul? You know, the case law that talks about it's basically harmless error.
So, to my memory, I don't believe so, because the question that the core question here is, do we have a contract between the client and the lawyer, or do we not? Mm-hmm. Right? Mm-hmm. And so, our urging here is that the trial court assess this as we do not have a contract, and that's because the trial court based that finding on the violation of Rule 1.5e. And our position is that when you compare that to the prior decisions of this court, the trial court respectfully is reading into this a requirement that doesn't exist, is reading in a shares requirement. And the appellee urges this court to read in a shares requirement, because if we look at the appellee's brief, the appellee concludes by arguing that Clark was not informed of how the sharing arrangement was to be conducted. That reads in a provision that has explicitly been removed. So if we look at the ABA version of 1.5e, the ABA version of 1.5e says that the written undertaking shall include the share each lawyer will receive. Excuse me, I've read that wrong. The client agrees to the arrangement, including the share each lawyer will receive, is required. It's required under the ABA that the client agree to the shares. But when you compare that to the Tennessee version, which is identical but for that language, the Tennessee version says the client agrees to the arrangement and the agreement is confirmed in writing. And so I take from that, and I urge the court to agree that difference is the result of a decision, that someone respectfully above my pay grade has said this provision is not appropriate for Tennessee. Tennessee will not include this provision. We excise it. We adopt the rest of the language. And the comment respectfully, I think, bears that out by saying we have chosen not to require this. And so because of that, we don't have a situation where the contract is invalid. We don't have a situation where the parties have failed. Even if the court, and we've touched on this a bit, but even if the court finds that this contract fails the requirements of 1.5e, we still are closer to compliance than in Cordova and closer to compliance than in Coleman, because in those cases they're not as I read those cases, there are no written undertakings relating to the association of another lawyer at all. There is no notice to the client about bringing in someone else. There is no written agreement. I think that in Coleman, it's apparent that there is another lawyer because the client in Coleman is actively working with all the lawyers involved. In Cordova, it's a little unclear. It reads to me, and I'm happy to be corrected, it reads to me as though the additional lawyer is sort of working behind the scenes and may not be dealing with the client. But in either event, we actually have a writing that tells the client about this other lawyer. And as I've said before, I just want to highlight, we have a case where the client has actual knowledge of the other lawyer. We have a case where the client is aware that it is contemplated that the lawyer's fee will be divided among the lawyers, but will not change the client's recovery. So there's no prejudice to the client. There is no harm to the client. In fact, if anything, it inures to her benefit. She has 2 lawyers but pays no more. She has not been asked to foot the bill, as it were. It's coming out of Mr. Baker's share. And so when you say when the writing says to the client, there may be other lawyers, but that lawyer will share in my recovery, not yours. And then the other lawyer is there, meets the client, knows the client, works with the client, attends mediation, then respectfully, the client is not in a position to complain that they have been done unfairly, that they have been tricked or dealt from the bottom of the deck about this other lawyer, right? And so for all of those reasons, we respectfully urge this court to find that Rule 1.5E does not operate to invalidate the contract in this case, that there is a valid contract as between Ms. Clark and Mr. Baker, and that the trial court respectfully should be reversed. Thank you for your time, Your Honors. I look forward to rebuttal argument.
You have your time for rebuttal. We'll hear from the appellee.
I don't know the plural of Your Honors, so I'll just say, may it please the court and good morning.
Just add an S.
Your Honors. Good morning,
There
Your
you
Honors. Mr. Hedrick's right. For purposes of this,
I'm sorry, counsel, you are,
I apologize, Your Honor.
that's all right.
I'm not used to being not heard. We're not contesting Mr. Jones' contract.
I'm sorry, what's your name?
I'm sorry, Your Honor. My name is Keith Stewart. I'm of the Knox County Bar.
Thank you.
Practice right across the street.
Like I said, for the video, we need.
I understand, Your Honor. I don't get up here much, so I apologize. For purposes of this appeal, Your Honor, we're not arguing that Mr. Jones had a valid contract. The underlying dispute here was that Mr. Jones and Mr. Baker represented Ms. Clark together. At the point in time, they were practicing out of the same office. Mr. Jones had a contract that predated any contact with Mr. Baker, and then Mr. Baker, once he came into the case, there was a second and third contract, and that's what we're talking about here. Judge Stevens determined that none of the contracts complied with 1.5E, and our position is she was correct in that for a couple of reasons. My understanding is the rules of profession.
No question, everybody agrees that the Jones-Clark is invalid.
Yes, Your Honor.
Jones-Clark.
Well, let's say it doesn't comply with 1.5E.
Well, the issue that's up before us is whether or not the contracts are invalid.
Well, okay.
So the answer to that would be, is you all agree that it's invalid for whatever, for 1.5?
Correct, Your Honor.
Okay.
That's
I'm
correct.
Sorry, go ahead.
My understanding is the rules of professional conduct apply not only to the relationship between client and client, but also lawyer to lawyer. And while Mr. Hedrick argues that no disclosure, there's a divergence in the Tennessee rules from the model rules, that language about the division, that he says it's compliant to simply let the client know that they won't they'll have a second lawyer or third or fourth or whatever with no more fees being due. I respectfully disagree, because Where we have a problem is in the transparency and in the boundary lines, is that there's no agreement between these attorneys, which is why we're here today, which is why we've been in this litigation.
But that's not really the issue that we're here for. That's a separate issue, I think, as to what ultimately happens between Mr. Jones and Mr. Baker, depending on whether or not we find this contract valid or invalid. But as I understand it, the issue is not that. Is the contract valid between Mr. Baker and Ms. Clark?
Well, actually, Your Honor, the issue is whether or not Mr. Baker's contract, since we've disposed with Mr. Jones, whether Mr. Baker's contract is compliant with Rule 1.5E.
Right, but that's a contract just between him and Ms. Clark. Mr. Jones is not a party to that contract.
That's correct.
Right.
But again, if we look at the components here, well, when I was working on this, because I've done a lot of work on contingency fee agreements, and I'm always very mindful of this provision, or I try to be. And I thought about Robert Frost's poem, Mending Wall. Good neighbors make good fences. That's the problem here. Without getting too deep in the weeds, Ms. Clark went to Mr. Jones. Mr. Jones then went to Mr. Baker. Ms. Clark, throughout this whole thing, thought she was being represented by both lawyers equally.
I think there's definitely a problem in the communication between Mr. Jones and Mr. Baker in terms of what was the expectation of who was doing what and what they were going to split. But I think that is for maybe sometime down the road. I don't know that that is our issue today.
Respectfully, Your Honor, I think if we're looking at Rule 1.5E, which is what Judge Stevens looked at, I think we need to take into consideration the fact that Ms. Clark, in her agreement with Mr. Jones and with Mr. Baker, she relied on what they told her. She relied on what they were putting forth. I think we have to look at this from the client's perspective, not necessarily the lawyer's. I don't see Rule 1.5E as a floor. I see it as a starting point, because the purpose here is we're representing clients. It's their interests that are paramount, and this...
So if we look at it from that point of view, in what way was your client harmed with the enforcement of the contract that she signed, agreeing to the 45%? Because she read it, she signed it, she agreed to it, she's not being charged any more or any less. She got what she bargained for.
Well, Your Honor, in the underlying case, as I said, we conceded on Mr. Jones' contract. She had a contract with Mr. Jones, which was for all intents and purposes identical to the one with Mr. Baker, but it called for a 1/3 contingency.
Right.
Mr. Baker's contract is 45%.
It's not really identical. Does it reference that other lawyers may be retained and brought in, but it will not change your fee?
I believe it does, Your Honor. I can't say that for certain as we stand here, but her understanding is that her fee was 1/3.
Well,
and
then why did she sign another one that said her fee was 45%?
Your Honor, I can't answer that. What she's told me is whatever her lawyers put in front of her, she signed because she trusted them. This all came to a head when she went to Mr. Jones and said, hey, I did the math on this and it doesn't add up. And he's like, well, what do you mean? And so then there was this whole...
Let's simplify it for me.
Certainly, Your Honor.
Tell us how the Baker contract does not comply with 105E.
Your Honor, it's our position that there was an agreement for a division of fees between these lawyers as to Mr. Baker and Mr. Jones. That's a question of fact for the trial court. But she was the true nature of this. I don't believe that catch-all provision of we can associate other lawyers is sufficient in this situation to cover, to validate this agreement. I believe that Judge Stevens got it right when she said it does not comply with Rule 1.5E.
But how? Just tell me how.
Well,
I mean, why doesn't that? When the agreement says the lawyer may involve other lawyers in this, and one or more other lawyers involved in it, but it will not change your fee. It will not increase at all. So why does she have to know the name of the lawyers that's going to be involved?
Well, that would certainly be best practices, but no, I don't believe that's it.
Does she have to know the shares, how the lawyers have decided, if they have, how the lawyers have decided how to split the 45% fee?
I believe that there should be some disclosure to the client, since because this is in reference to lawyers in different firms of how they're dividing those fees. I don't.
Comment 7 says it's not required.
Well, I understand that, Your Honor. I think I don't
You
have
don't
an
like
argument against
comment
that. I'm sorry?
You don't like comment 7?
Well, I don't agree with it in the sense that I'm trying to look at it from a client's perspective, not a lawyer's perspective, in that.
We don't get to just kind of decide on which ones we like or disagree with.
I understand that, Your Honor. Well, we can go on down and we can say that I guess my position, and I haven't fleshed this out entirely, is to me, the language in Mr. Baker's contract does not satisfy that she agreed to that arrangement, because she had previously hired Mr. Jones. She then is just signing documents her lawyers are telling her to sign. But I guess number 3 under E is where I would land, is the total fee is reasonable. I don't believe it complies with that, because it's a 45% contingency
That's
fee.
not the question before us on this rule.
Well, Your Honor, respectfully, she said
It's
that
just
it
whether or
doesn't
not the
comply.
contract- Whether or not the contract's invalid.
Well, Your Honor,
That's probably going to be something the trial judge is going to later, depending on which way we rule.
well, I'm not sure exactly what Judge Stevens relied upon. I don't think she parsed it out to that extent, but she found it invalid under 1.5E. And part of that is number 3, the total fee is reasonable. So it could very well be that that's what she landed on. It could be that she didn't believe the agreement was confirmed in writing, or that she believed that the division had to be disclosed. I don't remember arguing comment 7 down below, but the fact of the matter is Judge Stevens determined that both contracts did not comply with Rule 1.5E. Now, and that's, we agree with her. We believe that is true. So, I was trying if I could have one moment, Your Honor.
Yes.
No, I don't. I can't find it. I was looking for the amended order that Judge Stevens signed, but I believe it was simply the question for Your Honors would be, and it's a pure question of law, I suppose, because there's really no facts in dispute. It's, does it comply with Rule 1.5E, and that's it. So,
Anything else?
thank you, Your Honor.
Thank you. We'll hear from the appellant rebuttal.
Thank you, Your Honors. May it please the court, the issue before the court from our March 3, 2025 order is limited to whether, as a matter of law, the retainer agreement between Baker and Clark and the agreement between Jones and Clark are invalid because of the failure of compliance with Rule 1.5E. That's what we're limited to. We've already disposed of the agreement between Jones and Clark, leaving only Baker and Clark. And if we look at the trial court's order from February 1st of 2024, in which the trial court denies the motion for summary judgment, leading us to it's the order from which is appealed. The trial court's analysis is focused, if I may summarize, from our position, the trial court's analysis is focused on communication and notice to the client and not on the reasonableness of the fee amount. So in reviewing this, while I am appreciative of Appellee's argument, I think it is plain from reading the trial court's order that the trial court's ruling rested in the notice and consent provisions of Rule 1.5E and not in the reasonableness of the fee provision of 1.5E. When it comes to that, it's
Oh,
not
yeah,
a.
she specifically said she deferred the issue of reasonableness.
I think
There's
that's,
a genuine issue of material fact as to reasonableness.
you've done a better job than I, Your Honor. So I think that we cannot question the reasonableness of the fee here, merely the communication. And in my final few seconds, I will urge the court to find that when we're talking about harm to the client, there is no harm to Ms. Clark. Ms. Clark settled a case with no physical injury for $175,000 and received her share by the contract she signed, repudiating all other contracts. She had that contract with if she had a contract with Mr. Jones, she came into Mr. Baker's office and signed his contract, which in writing said, I am rejecting, repudiating, undoing all prior contracts. This is the contract I want. And so there is no harm to the client. I am far over my time. I thank you, Your Honors. I hope you have a nice day.
Court's thanks to counsel both sides. Excuse me, we appreciate your argument this morning and your briefs in this matter. We would recess court till 1:30 this afternoon.
All right. This Honorable Court of Tennessee stands adjourned until 9.